I assume. Again, this could be some crazy stuff that's going on. I just wouldn't know, but that's how it seems to me. Here we go. Here we go. Here we go. Now we're talking. That's the thing with sick, hateful creeps online. I say this as one myself, is whenever they get mentioned in some official document, that's like gold. That's like, oh boy, let's go. You know? Bonnell's pattern of behavior of recklessly sharing intimate images without authorization. Interesting stuff here. I would say there's something of a pattern of that happening. By the way, guys, that video is still on Kiwi Farms. You know, look at it if you want. By the way, guys, by the way. Yeah, that was a really smart tweet that guy put out. Didn't you think there was such thing as an imagining device? There was a typo on a page that I read, okay? It wasn't I didn't just come up with that, okay? So, we've got some Destiny news, okay, guys? Huge Destiny news to go over right now. I'm just gonna pull up this Reddit thread because I don't have the documents to hand. So, basically, despite Destiny's posturing in his chat, it appears that there's a jury date, a jury trial date has been scheduled on the Pxie suit. Jury trial date. So I've just updated my title. Okay. So I'm just looking at this. This is, I guess, the docket. So it says, this is, what? It says the 3rd of April. This is yesterday. Setting trial, calendar call, pre-trial deadlines, and pre-trial procedures. Jury trial set for the 18th of May, 2026. Oh, it's not 2025. I read this earlier. I assumed 2025, but no. This is jury trial set for 2026. 18th of May, 2026. 9:30 a.m. before Judge Jacqueline Becerra. Becerra? I don't know. Calendar call set for 12th of May, 2026. 10 a.m. before Judge Jacqueline Becerra. An order referring case to Chief Magistrate Judge Edwin G. Torres for discovery matters. Signed by Judge Jacqueline Becerra on 3rd of April, 2025. I keep up the dates because obviously we do it different here. See attached document, full details. Okay, and then I assume we've got the attached document in the comments. Joint scheduling report, Rule 16.1 by Jane Doe. That's obviously Pxie. Stephen K. Bonnell. Yep, okay. And then today. Is it today? Yeah. Clerk's notice to filer. Plaintiff's motion, temporary restraining order, and preliminary injunction. Motion with multiple reliefs filed as one relief. Error. The filer selected only one relief event and failed to select the additional corresponding events for each relief requested in the motion. The docket entry was corrected by the clerk. It is not necessary to refile this document, but future filings must comply with the instructions in the CM/ECF Attorney Users Manual. So they obviously some procedural thing here, Pxie's lawyers or whatever, mess up some procedural thing with requesting a temporary restraining order and injunctive relief. So I assume it sounds like that's fine. I mean, it says the clerk corrected it, so I can't see that's a massive issue. This is not necessary to refile. And filer select the wrong motions relief. Error, filer select the wrong motions relief during the docketing motion. The correction was made by the clerk. Not necessary to file the document. Future motions, yeah, okay. So that's again, same thing. Motion for temporary restraining order and preliminary injunction. Read 20. Plaintiff's motion, temporary restraining order, preliminary injunction. Filed as one relief. File select only one relief event. Okay, it's basically the same thing again. Select the wrong reliefs when docketing the motion. The correction was made by the clerk. It is not necessary to refile this document, but future motions must include applicable reliefs. Okay. So again, this is just a couple of procedural things, it sounds like, that were messed up in the filing, and the clerk has corrected them, and instead it's not necessary to refile on all of them. Plaintiff's motion for temporary restraining order, motion for preliminary injunction, is order granting motion. Text of proposed order. Plaintiff's proposed order granting motion for temporary restraining order and preliminary injunction. So does that mean that that's been granted? Does that mean that the injunction and restraining order have been granted? Is that what I'm reading there? I'm honestly not sure. Again, I should preface everything I'm going to say in this segment with, I'm not a lawyer. I've got no experience with the American legal system. Take nothing I say as conclusive or fact, and I'm going to seriously try to caveat and withhold any conclusive analysis, okay? Entered. So, yeah, but they all say entered. I don't know that means anything. I don't know that means anything. I'll have to wait. I'll have to see a law tuber talk about it, because they're always, I know they always have perfect analysis, and there's never anything that law tubers say wrong ever, because a lawyer could never get something wrong about the law. Anyway, let's read some of these actual documents here. It says order, it's from the lawyer. It says granting motion. I don't know. Yeah, I don't know what any of that means. No idea. I wouldn't assume it means anything until we get better evidence on that, until we get some good analysis on that. So, 2-week period beginning May 18th, 2026. Dude, I hope we get a trial. I hope this goes to trial. I would love to fucking watch a trial on this. I would love to watch a Destiny trial. That'd be freaking epic. Would that not be epic? Would that not be awesome content? Would it be live streamed? Surely it would, right? Surely Florida do live stream trials. Right? It wouldn't be. Would it be? It would be on TV, surely. Thanks up to the judge. Oh, maybe it wouldn't because she's Jane Doe. That could be annoying. I just want to watch it. I want to watch it. I want to make the money. You can request it. It feels like if it's super public, there's no reason not to stream it or whatever. Can also go in person. Yeah, I'm not visiting America while Trump's in the White House, to be honest. I don't want to get my phone seized and then get thrown in some fucking El Salvadoran black site for saying that the world would be better off if... You know. Anyway. Let's read this. All motions to join additional parties and amend the complaint must be filed. Parties should exchange a written list containing the names, addresses, and summary/reports of any expert witnesses intended to be called at trial. Only those expert witnesses listed shall be permitted to testify. The summary/reports shall include the information required by Fed R Civ P. I don't know what any of this means. List of experts' qualifications offered at the trial, publications and writings, style of the case, the name of the court. The judge in cases in which the expert has previously testified, and the subject of that expert testimony, the substance of the facts, and all opinions too, which the expert is expected to testify, and a summary of the grounds for each opinion. Parties should exchange a written list containing the names, addresses, and summary/reports of any rebuttal expert witnesses intended to be called at trial. Only those expert witnesses listed should be permitted to testify. Summary/reports shall include all information required by blah 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 blah. Lists of the experts' qualifications to be offered at trial, publications and writing, style of case and name, blah, blah, tell us about your expert witnesses. Okay, that's what we're getting from this. All discovery should be completed by the 16th of December, 2025. 23rd December, all mediation should be completed. 30th of January, 2026. All dispositive pre-trial motions. This is all just deadlines. These are all deadlines. Pre-trial motions and memoranda of law, as well as any motions to exclude or limit proposed expert testimony, must be filed. Any Daubert motion should be accompanied by appropriate affidavits. If any party moves to strike an expert affidavit filed in support of a motion for summary judgment for reasons stated in, that would be Merrill. I don't know any of these laws, I don't know any of these statutes. I can't really make any interpretation about any of this stuff. I assume this is pretty boilerplate. I assume this is all pretty boilerplate for like any civil litigation. These are just roughly things you need to do and the time frames they give to, you know, do discovery and have everything in order. I assume. Again, this could be some crazy stuff that's going on. I just wouldn't know, but that's how it seems to me. All pre-trial motions and memoranda of law must be filed. Parties must file joint pre-trial stipulations set forth herein. Yep, this all seems just like standard stuff. With all deadlines, no later than 3 business dates. So, I mean, this is... It's good for getting sort of like a picture of how this is going to go down, I guess. So basically, throughout the course of the rest of this year, it's going to be stuff like discovery, negotiations. By the end of the year, if they haven't settled by the end of the year, if this isn't all, you know, sorted by the end of the year, then it seems like it will be going ahead into next year, right? Because it was like there's a deadline for the negotiations and everything. The mediation should be completed by 23rd December. Trial procedures, okay. Okay, wait. There's a Kiwi Farms mentioned there. That'll be interesting. Let's see if we can figure out anything else from this stuff. This is page 4. Bench trials. What are we here? So this all looks like standard stuff. Pretty standard stuff. Notice price order. Okay. There's Lentrick filed the foregoing document with the clerk of the county. What page is this from? 5. So that's point 5 and 6. Where are we drawing this from? Defendant shall send, pursuant to authority of this court, a written request to third parties, including social media platforms and internet service providers, including specifically Kiwi Farms. Okay. A bunch of sites that I probably shouldn't have the URLs up for. A bunch of adult sites that probably have content hosts on them. So, okay. But where's that coming from? Because that was all numbered, and I didn't see other stuff with just like numbers. So I don't know where it's getting drawn from. I don't have the link to the doc again. Why are you looking at Bolex OF? Okay, bro. Okay. Yeah, it feels like I'm missing something here. It definitely feels like I'm missing something here. Yeah, I need to get, like, what, I don't know, fuck, man, I literally can't find the website. Here we go. Oh my god, don't make me do this. What? How do I get these documents? Yeah, firstly, how do I get this stuff? It seems like that whoever that is on Reddit hasn't gotten all the stuff that we need. They've not done their full job. They got lazy. Okay, no one knows how to get this, no? Firsty? No help? Do I actually have to pay? I'm not paying. Fuck that. Fuck that. Court listener recap archive. Search for Doe v. Burnell. Doe v. Burnell. Here we go. Now we're talking. Okay. So these are the two ones here, I think. So the motion for injunctive relief and temporary restraining order. Right. Let's have a look at this then. Okay. Let's just scroll through some of this. Let's see what's going on here. Plaintiff hereby moves the court for a temporary restraining order and a preliminary injunction to enjoin defendant Stephen Bonnell II from further sharing, distributing, or publishing the intimate images, videos, plaintiff, compelling Bonnell to remove all publications of the videos and all messages between him and the plaintiff, from all forms of public media he controls, either directly or indirectly, and of all messages between him and plaintiff. Oh, so they want him to take down the leaks that he's done since, like the leaks of him talking to Pxie. Okay. Ordering defendant to retrieve the messages he has deleted, to cease and desist from destroying evidence, and to preserve all discoverable information relevant to this action from his phones, computers, tablets, online accounts and platforms, or any other devices, and preserve all internet routers or other hardware in their current form or image, so they may be searched for information relevant to this action. Okay, so, I mean, so this is like a data preservation order, basically. Order to preserve evidence. I hope they've spoken to Discord in advance, because he's already deleted everything. I would guarantee. Defendant Bonnell, a well-known live streamer and political commentator with millions of followers, induced plaintiff to meet him at a hotel and engage in sexual relations while being videoed. Videos one of the videos, if not more, without plaintiff's knowledge or consent. Okay. February 2020, prior to meeting Bond at the hotel, plaintiff expressed to him a direct message concerns her privacy. I'm okay with people knowing we're hanging out. If anyone asks questions about sex or anything along those lines, I'd rather deny. Jesus, sorry. Keep that private between us. The plaintiff's declaration, Exhibit 1. Plaintiff also discussed the privacy concerns regarding their relations and the videos directly with Bonnell when they met at the hotel. And this concern was reiterated in March of 2023 when a woman, Lav, that's Lav mention, a woman, Lav, mention, whereupon Pxie, a woman, publicly alleged that Pxie had sexual interactions with Destiny. Why does it say Pxie here in the lawsuit? There's like Doe. It's Jane Doe. But it says Pxie. They say plaintiff's screen name is Pxie. Oh. So they actually do use the screen name. Interesting stuff. Interesting stuff. So I guess the purpose of the Jane Doe thing is just to protect her legal name then. Fair enough. Fair enough. What, Destiny's tried to go against that too. So, what have we got? Whereupon Pxie messaged Destiny and asked if he had told anyone about their relations. He denied telling anyone other than his wife. Pxie, okay. So there was actually some disagreement here. There was actually, well, not disagreement, it's disagreement. But Jay Stook was saying to me at one point, oh, these messages between Pxie, because there are some messages between Pxie and Destiny, where basically Lav has accused Pxie of sleeping with Destiny. Pxie has gone to Destiny to ask about, like, how she might know. That's pretty obviously the setup. And Pxie replies to some message that Destiny sends her by saying, and we don't know what message Destiny sent. Pxie replies to it by saying, I haven't told anyone on my end either, or no one knows on my end either, or something like that. And basically, I was always saying that, well, this shows that Destiny was telling her that he couldn't have told anyone, as such, hadn't sent the video, because obviously if he'd sent the video, then people would have known that is just telling people that you slept with her. So he had lied. So he knew that she didn't want people to know this, and he lied about it. However, it wasn't proven that's what he said in that message. Now, in this court document, it is apparently what he said in that message. He said that he'd only told Melina, even though at this point, other people had received the videos. So that just absolutely rapes his retarded implied consent argument, because he kept sending that video past when she reached out to him, as far as I'm aware. As far as I'm aware. Okay. So, as set forth in the complaint, the defendant disseminated through electronic means one of the videos, to an individual using screen name Rose. Rose was a random fan of Bundles' Discord platform. I saw that Destiny was saying he's not going after Rose or Kiwi Farms anymore either. He's not going after Rose, Solo, Kiwi Farms, anyone. He's given up on that. And he's blaming the fact that he's wasted so much money dealing with Pxie. That's not why he's not going after them. Everyone knows why he's not going after them. He's not going after Kiwi Farms because it would be complete public suicide. And he's not going after Solo and Rose because he thinks there's a solid chance that she was 17 when he was sexting her. Because he didn't check her age. He didn't check her ID. So, unfortunate. Unfortunate. And we all know that's the case. Everyone, it's time to stop pretending that's not the case. That's obviously what's happening. He's got the money. He could go after multiple people if he wanted to. He's choosing not to because he doesn't want to find out. He doesn't want to find out. He was absolutely terrified talking to J-Stalk, being like, that's the one thing that I can't sweep, is if she's a 17-year-old. That's the one thing that I can't sweep. That's what he was saying. It's just... So, yeah, and the labels their identity. These 25 videos included videos of Bonnell's ex-wife, Melina. Public said she didn't consent. Links to a DGG Snark Reddit post in the fucking court documents. Dude, they're gonna be having a fucking great day, aren't they? Oh my god. Still on Kiwi Farm site. Okay. Lots of mentions of DGG Snark, Kiwi Farm, stuff like that in here. I thought there's gonna be some people very happy about that. That's the thing with sick, hateful creeps online. And I say this as one myself, is whenever they get mentioned in some official document, that's like gold. That's like, oh boy, let's go. You know? Your looks don't match your voice. Is that a compliment or an insult? Who knows? But I've heard it many times over the last week. I'm not gonna lie. Yo, thank you for the $20. Legally blacked. So many great videos to show a jury of destiny. Thank you. That is a great comment. Hugely appreciated. Okay. Okay. Bono also explicitly admitted in a direct message with a follower by the screen name Straighterade that he distributed the video non-consensually. Bono goes on to say, I don't really care about the legal side or whatever. Obviously, I've severely, at the very least, psychological damaged Pxie. Although Bono has only explicitly admitted to sending the video to Rose, he's intentionally or recklessly shared the video to others as well, without plaintiff's knowledge or consent, even after the first video was published on pornography sites and after his alleged remorse. Indeed, on or about 9th of January 2025, Bono was communicating with one of his fans, Hannah Brooke, on the Discord platform and offered to send her the video. I don't know if that's quite what was happening in those DMs, but sure. Yeah, I don't know that's quite what was happening in those DMs. I think that's either a misreading or a misrepresentation by Pxie's lawyers there, but whatever. Whatever. I'm choosing to believe Kuihman is still a faceless voice and this person on screen is an AI creation. Okay, man. Okay. The evidence presented... Wait, so... Yeah, so recklessly sent, Hannah Brooke, yeah. Evidence presented here of Bono's non-consensual sharing of the video is quite possibly only the tip of the iceberg based on the November 29th leak of the 25 videos that Bono had shared non-consensually, as well as a history of non-consensual sharing, and for there is a strong likelihood that he shared the videos with other people. I mean, that's true. Commencing at the minute 53 of the recording, Bono tells his followers intimate sexual details about plaintiff that he had shared with him, that she had shared with him through the private messages. He even posts screenshots of different message threads with the private messages between him and plaintiff containing explicit sexual details. So yeah, this is about his response on the 19th of February, where he leaked a bunch of shit. So yeah, as expected by many people, that's something. When you go on your live stream, when you're already being sued by someone for non-consensually disseminating sexual imagery, if you then go on your live stream, start talking with the person's legal name and disclosing more sexual details, their lawyers might pick up on that and try to use that against you in court. I don't know if anyone wasn't aware of that before today, but it's a good lesson for those of you. Dude. I'm 26, not 18, but sure. The defendant sharing the video and publication of private messages caused plaintiff extreme emotional distress. Plaintiff has suffered depression, suicidal ideation, recurring nightmares, humiliation, anxiety. The humiliation is enduring because the video and private messages have been and are still available to the public. Plaintiff believes their existence and accessibility have, and will continue to, tarnish her reputation, both personal and professional. She lives in constant fear that people she encounters have the video of her, and consequently, she has become very reclusive. She's also highly fearful that Destiny still has the videos and will continue to share them. That makes sense. Bono's pattern of behavior of recklessly sharing intimate images without authorization. Interesting stuff here. I would say there's something of a pattern of that happening. Let's see what they say. Approximately 15 women reached out to plaintiffs how they received sexually explicit images from Bono of other women without the other women's consent. Numerous women, including Bono's ex-wife, Melina Goranson, and Stasia, have recently come forward with publicly alleged that Bono has shared sexually explicit videos of them without their consent. Okay. More DGG snark. These images were then posted on different pornography sites without their consent. On January 20th, 2025, a woman with a screen name Cherry posted on X that she had just found out that Bono had secretly made an unauthorized audio recording of their sexual interaction and then shared it with other people without her knowledge or consent. January 22nd, 2025, Cherry posted on X that she filed a police complaint about Bono's unauthorized recording and sharing, and that she is very worried about harassment. On or about January 24th, 2025, a political streamer by the screen name of Denim speaks on her forum about Bono's sharing of the video. She informs her followers that Destiny/Bono had recorded a sexually intimate conversation with her without her knowledge or consent. She alleges that after the personal relationship deteriorated, he became publicly hostile towards her, and later he posted to his followers that he has the recording and he could publish it. Russell Search link there. Awesome stuff. Very epic. I think Denim's claims that the conversation was sexual. I'm not sure, though. I'm not 100% on that. Crazy's reading this in a jumpsuit. The jumpsuit's awesome. Okay, quit hating. Quit hating. Dude, this fucking bottle's lid is broken. There we go. There we go. Don't say orange is your new black. I get called a lesbian enough, okay? We gotta cut that out. Bonnell posted one of his DGG community group chats involving multiple people at plaintiff/Pxie is just after his money. Bonnell also posts on his website, destiny.gg, and in DGG chat, Pxie and the people behind it just want money, so there's no point going after the hacker. He's probably some broke loser anyway, without even mentioning him. Why? Why are you guys going after me? Why are you guys hating on me? Why are you hating? Bonnell makes another defamatory post on X, telling his followers plaintiff cares about getting money. Okay, blah, 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 blah. He also informs all of his followers that the video can still be seen on Kiwi Farms. Yeah, that was a really smart thing he did when he's like, by the way, guys, that video is still on Kiwi Farms. You go look at it if you want. By the way, guys, by the way. Yeah, that was a really smart tweet that guy put out. Guys, guys? Guys, Subaru is crazy. What is happening? I'm being raped. I'm being raped. February 21st, 2025, Bonnell tells the entire Discord community that Pxie was dating her supervisor at her prior job. That the supervisor was like 25 years older than her. It's about Pxie. It's about Supreme, rather. Obviously, it's about Pxie. It's all about Pxie. Obviously, it's about Supreme. Is what I meant. This was deliberate untruth meant to only to harass plaintiff and retaliate against her for initiating this action. Plaintiff had told Bonnell that she dated this man briefly, but it had ended prior to his starting work at the company. There was no reason for Bonnell to believe that the man was ever her supervisor or that he was 25 years older than her, because he was not. Bonnell has retaliated against Cherry by publicly posting private messages with her during a time when she was suffering a mental health crisis. Bonnell retaliated against Denims by posting private sexual messages between them in his community group chat. When's the music stream? Okay. On January 23rd, 2025, Counsel for Plaintiff, so what's this? Bonnell's wanton destruction of evidence. Counsel Plaintiff sent a letter via messenger to Bonnell advising him of the impending legal action and demanding that he preserve all evidence, including electronically stored information, ESI, in compliance with the law. See Letter Exhibit 3. Instead of preserving evidence, however, Bonnell has systematically been deleting and destroying evidence. Indeed, on January 30th, 2025, Destiny/Bonnell admits that he has been actively deleting evidence of his wrongdoing, specifically his messages with multiple women who have claimed that he shared sex videos with them without the participants' consent. And as early as January 21st, 2025, aware of the impending lawsuit and potential criminal investigation, Bonnell starts destroying evidence, including deleting messages between him and plaintiff. Wow. I mean, you say this will hurt his case a lot. I'm never sure about this stuff, man. I understand we all want to think that, you know, the legal system's epic, and if you start destroying evidence, well, we know we know you're up to some fuckery, and we're gonna get you for something. But yeah, I'm not too sure. I'm just super hesitant to get my hopes up or have any conclusions or anything like that, because just I don't know fuck all about law. I don't trust law tubers. Destiny's whole plan is to have it dismissed because of the October 2022 typo by Pxie's lawyers. There's no way. Why would an October 2022 typo get it dismissed? They've got a jury date set. What, they can just dismiss it based on some typo date in... That doesn't make a lot of sense to me. Something about how that typo makes the statute unapplicable by dates. But it wasn't... I don't know... Okay. I don't... Well, the typo might get the case dismissed if that typo was actually like a lie to change the date of an event to make it fit within the statute when it otherwise wouldn't. Right? That could get a case dismissed. But I don't know that's what happened, and my understanding was it wasn't the October 2022 thing. I thought it had to be later for the statute to count. Court just says trial dates, early in the case, make sure it's there. Right, okay. Pxie's lawyers misread an EU timestamp from a Discord message. Right. Yeah, I imagine that would just be like they would just want them to refile it, unless it just like unless the statute straight up just didn't apply. They would just ask them to refile it, right? I would have thought. We'll see, I guess. But I didn't even hear Destiny specifically cite that. You're saying that's Destiny's whole plan is to get that dismissed. Wait, who said this to me in the first place? Oh, yeah, you're just pulling this from KF. Okay, yeah, this is like okay, don't say things as fact if they're retarded theories, okay? I understand there is some weight to that theory, because the idea is basically about this, because me and Jason have spoken about this a lot. Don't state it as fact as if it's just a theory, please, I'm begging. Because there is some truth to that, the idea that basically, the statute came in at a certain point during the timeline of all these things happening, and some instances of him sending it are before the statute came in, and some are after. The Rose one, as far as I understand it, that is actually before the statute came into effect. Now, there are other instances of him sending it that actually are after that date, according to Pxie's initial filing. So I don't believe that the date of that Rose message being sent actually would determine whether it gets dismissed or not. That seems to me like the sort of thing that would just be corrected and refiled. I can't see that Destiny could reasonably get it dismissed off of that one date, because there are still instances they're claiming that are past that date. I don't think it's quite right. It could be. Who knows? Who knows? Let's keep reading here. So, what have we got? Streamed by the name of Ahsoka Bono, message plaintiff recently informed that Bono had deleted all messages between them regarding his non-consensual sharing of videos. I'd messaged Destiny in the past and sent videos of him with women. I didn't recognize any of the people in the videos, bar one. Seems to have included Melina. But I assumed it was consensual. I don't know if it helps at all, but some proof I did converse with him and that there's now no messages. Bono also deleted all his direct messages with a follower by the screen name of Psychodynamic, with whom he had shared videos of other women without their consent. The court may enter a preliminary injunction or a TRO, same four factors. Okay. Okay, I think this is all pretty standard stuff. It's just about how TROs work, and they're asking for one. I don't want to get too much into all the legal stuff, because I can't draw conclusions on it. Like, I don't know what almost any of this means. So, like, anything I can try and say about this is, like, totally retarded. You might as well just... just watch a child draw with crayons instead. It'd be just as worthwhile as my legal analysis on that. Here as detailed above, defendant has expressly admitted in writing that he shared the videos with Rose without plaintiff's consent. There's literally no excuse. Oh, wait. Also, this is what I need to do. Guys, huge thing happening right now. Huge thing happening right now. We've got a goal going up. Epic legal content goal. Okay? That's the goal that's in chat right now. 20 super chats for the epic legal content goal. I've totally given up. Totally given up on the goal names. Okay, guys. Also, like the stream if you're here right now, okay? 400 people watching. 6 likes on stream if you wouldn't mind, please. Moving your cursor, thumbs up and clicking it. Pressing the thumbs up on your mobile device. That'd be huge appreciated. Anyway, let's get back to this. So. Recently informed all of his followers they could watch a video on the Kiwi Farm site. Video was disclosed in interstate commerce on various pornographic platforms. So, this is for the... Okay, plaintiff has made a prima facie showing of the elements of Florida Statute 784049. Okay, so this is the sexual cyber harassment criminal statute, okay? So this is something that people have... that there's a lot of disagreement about. You know, even, you know, anti-Destiny people, even myself, J-Stalk, will say, very unlikely that Destiny gets got on sexual cyber harassment because it requires, like, so much intent. However, could some of Destiny's actions since this happened help construct that intent? I wonder. Let's have a quick look at what they say here. A sexually explicit image includes any image depicting sexually personally explicit conduct. There is no question the video is a sexually explicit image that was disseminated by Bono through electronic means and published to the internet without plaintiff's consent and in violation of her expectation the video remain private for no legitimate purpose. Accordingly, plaintiff is more than likely to succeed on the merits of her claim in violation. Okay, more than likely. Yeah, okay, there's not... They haven't really done a lot extra there, but maybe there's more stuff in the rest of this. Plaintiff was made a prima facie showing of the elements of intentional infliction of emotional distress. Bonnell's non-consensual sharing of the video, which he continued to share after its November 2024 publication on the internet, and despite his awareness and acknowledgement of plaintiff's extreme emotional distress. Yeah, see, you can construct, like, quite a rough reading here, I feel like, for a courtroom, where he is, acknowledging the harm he's caused Pxie, acknowledging he fucked up, acknowledging that she's in a terrible place, receiving messages that she's in a terrible place, and gonna stop herself, entertaining that as a serious possibility, and then goes on to tweet about how you can still go see the video on this website. Intent does matter. Intent doesn't. Why even say something so fucking stupid, Jade? Why even say something so fucking stupid? Why even say something that is quite so fucking stupid when we're reading a filing for a statute called intentional infliction of emotional distress? When we're reading a statute called intentional infliction of emotional distress, you come into my chat and you say, intent doesn't matter. Definitionally, it does. You fucking idiot. So please, never say something so certainly that is so blatantly wrong. I'm literally just timing you out from chat for 24 hours because you've shown to be 60 IQ. The law is called intentional infliction of emotional distress. That requires an intent. Obviously. That's why it's called intentional. So please, never say something so stupid in my chat so certainly ever again. I beg. I beg. I can't stand it. I can't take it. Let's carry on. This is like when Legal Mindset. You remember when Ladyboy Mindset was like... He was reading, what was it? Which statute was it? It was like it was a statute that said visual 1,000,000 times. And then he's like, oh yeah, I think Cherry's audio recording could fit under this. I think Cherry's audio recording could fall under this. Again and again. It says visual depiction, visual depiction all throughout the statute. He's like, oh yeah, I think Cherry's audio recording could fall under this. Like, bro, what the fuck are you talking about? Are you illiterate? Are you actually illiterate? What is going on here? Didn't you think there was such thing as an imagining device? There was a typo on a page that I read, okay? It wasn't I didn't just come up with that, okay? Okay, I don't know how much I can really get from all this. But I don't know all these statutes. I don't have like a fucking, you know, like I can't just interpret these numbers and then know what they're referring to. I don't want to sit here and go to every single statute and break it down. The offensiveness element is satisfied if the publicity given to plaintiff is such that a reasonable person would feel justified in feeling seriously aggrieved by it. It is shocking to the conscience that defendant disseminated the video on private messages, and such conduct is not tolerated by decent society. Defendant knew that the video and private messages were no one else's business and meant to remain private. Plaintiff has shown that 1. Bonnell disseminated the video to at least one person, offered to share it with another, and informed all of his followers where they could watch it. 2. The video was published on the internet and seen by tens of thousands. 3. The video is sexually explicit and thus offensive. 4. Bonnell published this to all of his followers on YouTube, and the private messages between him and plaintiff containing facts of an intimate nature. 5. The videos and private messages were taken in exchange with the intention for private use and not for dissemination. And 6. The videos and private messages were not a matter of public concern and are offensive. Certainly, a reasonable person would not expect images and messages of this nature to be callously disseminated and distributed on the internet. Thus, they do amount to private facts. Moreover, a reasonable person would be justified in feeling aggrieved by the dissemination and publication of sexually explicit images of herself on the internet without permission. Awesome. Makes sense. Accordingly, plaintiff is likely to succeed on the merits of her claim for invasion of privacy. Plaintiff will be irreparably harmed if defendant's conduct is not enjoined. Irreparable harm is established by demonstrating the type of injury that would befall the movement in absence of the injunctive relief is the type which cannot be undone by monetary remedies. The 11th Circuit has stated an ongoing violation of the right to privacy presumptively constitutes an irreparable injury. Okay. The only areas of constitutional jurisprudence where we have said that an ongoing violation may be presumed to cause irreparable injury involve the right of privacy. Okay. Furthermore, the Cardi statute... Cardi? Like Cardi B? Cardi? Like WAP? Like Cardi like WAP? Is that what they mean? Is that what they... Like Cardi like WAP? Like Cardi? Like WAP? Like that song WAP? Like Cardi? Dude. The court may, in addition to any other relief available at law, or the equitable relief, including a temporary restraining order, a preliminary injunction, or a permanent injunction, ordering the defendant to cease display or disclosure of the visual depiction. The risk of irreparable harm to victims of non-consensual disclosure is so great that Congress baked injunctive relief into the Cardi statute. Harms such as emotional distress are harms which lack an adequate legal remedy. Plaintiffs have shown the imminent risk of further non-consensual disclosures of intimate visual depictions of herself and humiliation from the same. Okay, I can't read all this. Plaintiff has demonstrated an imminent risk of further non-consensual disclosures of intimate images of herself by Bonnell and further humiliation from the same. To wit, there is evidence that Bonnell offered to share the video even after the November 29th publication. The Bonnell has a history of sharing intimate images non-consensually. This behavior tends to show that defendant poses an imminent risk of dissemination of plaintiff's intimate visual depictions. It is difficult to precisely value the plaintiff's right to not have pornographic videos of her and her private messages randomly disseminated and posted online. Further, it is remarkably difficult to remove images from the internet, and no amount of money can ever repay the damage to plaintiff's sense of privacy and trust. Indeed, the inability to ever truly scrub this content from the internet demonstrates how this is an irreparable harm that compounds each day. As such, injunctive relief is required to prevent this irreparable harm. The third element requires the court to balance the competing claims of injury and consider the effect on each party of the granting or withholding of requested relief. Okay. For the foregoing reasons, plaintiff Jane Doe requests a temporary restraining order pending the issuance of a preliminary injunction. Plaintiff seeks an order: 1. Enjoining defendant Bonnell from sharing, publishing, and transmitting, whether directly or indirectly, the videos and or private messages. 2. Compelling him to remove all publications of plaintiff's private messages, private information from all forms of public media he controls either directly or indirectly. 3. Ordering defendant to cease and desist from destroying evidence and compelling defendant to retrieve all messages that he deleted and preserve all discoverable evidence that is in any way related to this case or that could prove any non-consensual disclosures from his phones, computers, tablets, online accounts and platforms, or any other device, and preserve all internet routers or other hardware in their current form or image so they may be searched for relevant information relevant to this action, or be at risk of an order of spoliation. 4. Compel defendant to direct third parties, including Kiwi Farms, not those sites. Okay. Okay. So, that is one of the orders here. Now, there was a second document here. I don't know if there's much difference in this. Are they like the same thing or what? Yeah, this is document 21. Okay, okay. Check the attachment to the docs that are also underneath filing 21. Okay. Filing 21. Okay, and we need these 3 attachments. Is that correct? So read document 21, then read the other 3 attachments. Someone catch me up. All right, what's the TLDR? So basically, there's a jury date set for May of 2026. Discovery and mediation ends by the 23rd of December of this year or something. And, I mean, it's not been dismissed yet. Pxie and her lawyers are asking for temporary restraining order and injunctive relief against Destiny to get him to stop leaking sexual details about her and take down the sexual details he has leaked. So that's roughly where we're at right now. Kuihman drinking out that tiny cup will never not be funny. It's an espresso. It's an espresso. Don't mean asshole. What the fuck? Okay. Introduction. Plaintiff hereby moves to court for temporary restraining order, enjoined from sharing, further sharing, distributing content. This looks pretty similar. Yo, thank you for the raid, Toastify. Welcome in. Toastify Raiders. Epic Toastify Raiders. Welcome in. There was a bleach blonde piece in his hair. No, I have a streak of grey hair, actually. But whatever. Keep moving. Is there anything different in this? Or is this the same thing? This looks like it's basically the same thing. Okay, this is what we want. Unsworn statement under penalty of perjury. Plaintiff. Jane Doe. I, Jane Doe, declare as follows. I am over 18. Blah, 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 blah. I am a live streamer using the screen name Pxie. Okay, so this is Pxie's statement. I don't know that we really need this, because I'm assuming this is essentially just a summary of her relationship with Destiny and why she's suing. Believe Doc 28.1 shows that the motion is granted. Are you in Discord? Can you send me that so that I can try and figure that one out? Okay, we've got a statement from Hannah here. I'm over 18 years, blah, 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 blah. I've known about the video. Asked hey was something, something, something. Okay. That's just the intro. All right. On January 9th, 2025 at 1:36 p.m., Destiny offered to send me the video. Oof, I mean, I guess now that some shit leaked, if you want videos of me eating, I've got them. I responded at 1:55 p.m. Haha, no, don't show me that. Those are super private. I can't imagine how it feels to have something so private to be so public, even if you are poly and general, very sexual in general. About 2 weeks later, I took screenshots of the above chat thread with Destiny and some other messages between us as well. Shortly thereafter, another stream with the screen name JStalk on Discord published in his community chat threads between Destiny and other people, including my chat thread with Destiny containing the above quoted messages sometime in February 2025. I noticed Destiny deleted all his messages to me in that chat thread on Discord. So I think this is wrong. I don't believe Destiny was offering her that video. He's talking about him eating. He was not eating in that video. So I don't think that's what was happening. However, still deleting the messages, whether that's what happened or not, that is still deleting evidence if he's been asked to retain stuff. So. And this is a demand letter for preservation of evidence. Okay. Yeah, and the evidence retention letter is January 22nd, 2025. So anything you deleted after that is breaking that order. What's this? What's this? What's this? This matter came before the court on the plaintiff's motion for temporary restraining order and the preliminary injunction on the motion. Based on the motion, the plaintiff's supporting memorandum, and the supporting exhibits in the record as a whole, the court finds there is good cause to enter a temporary restraining order. In her complaint, plaintiff brings claims arising from defendant Stephen Bonnell II's non-consensual sharing of intimate images of plaintiff. Those claims account 1 for the violation of the civil action relating to disclosure of intimate images, Cardi B, show up again with the WAP. Okay, stop. The violation of the sexual cyber harassment statute. Count 3 for the intentional infliction of emotional distress, and count 4 for the invasion of privacy due to the unauthorized public disclosure of private facts. Each of these counts arise from the defendant's dissemination of at least one sexually explicit video in which the plaintiff is identifiable. The evidence presented by plaintiff, including the affidavit of Hannah Brooks, as well as the multiple evidentiary links, including the motion, demonstrates that the defendant shared at least one video of plaintiff with at least one person, that the video has been published on the internet on multiple sites and viewed by tens of thousands. The defendant recently offered to share the video with another individual. The plaintiff has suffered extreme emotional distress, and the defendant has retaliated and further humiliated plaintiff by publishing her private images, intimate messages. The defendant has a history of non-consensual sharing of intimate images, and dude, this is rough, isn't it? And that the video was published on the internet in November 2024 alongside other videos of other women. Dude, Destiny's getting raped in this document. Defendant has been deleting evidence of his non-consensual sharing despite having been served with preservation of evidence demand letter. Based on this record, plaintiff has met all 4 criteria for injunctive relief. The whip, plaintiff has demonstrated that 1, she is likely to prevail on all 4 counts of her complaint. 2, she is likely to suffer irreparable harm if injunctive relief is not granted. 3, the balance of equities weighs in favor of injunctive relief. And 4, the public interest is served by an award of injunctive relief. Accordingly, it is hereby ordered and adjudged the motion is granted. Defendant is enjoined from further sharing, publishing, or transmitting, whether directly or indirectly, any part of the video or image that depicts plaintiff or any plaintiff's private information, messages, or information. Defendant shall remove or cause to be removed all publications of plaintiff's private messages and private information from all forms of public media he controls, either directly or indirectly. So let's see if his video response goes down. That'll be interesting, won't it? What is video? Will his video response go down? Signature. Oh, wait, is this... If this isn't signed, does this mean the judge hasn't looked at it yet? Or does this count? Or is this... What's this? What does this mean? Not granted yet. So yeah, this is a proposed... So who puts this forward? Does a clerk put this forward, I assume, right? So the initial thing... So the request for TRO, I assume that's put forth by Pxie's lawyers. And then the clerk processes it. Is that right? And then... If the clerk... tell me if I'm wrong here, but I assume the clerk puts up the proposed letter and then the judge looks it over and decides if it's granted. I think the plaintiff writes that. Oh, okay. So, I mean, that might not mean anything then, to be honest. I can't read... there's nothing on 31, is there? Thank you for $5, Sick Fury. Thank you. It's not granted. It's not granted. It's not been signed. Right? This isn't signed, so this isn't actually ordered. There was a status conference today with the judge, and it says order to follow, so the judge will issue it afterwards. Paperless minute entry proceedings held before Judge Jacqueline Becerra in person and Zoom. Status conference held on the 4th of April. Attorney appearances, Andrew Brettler via Zoom. Andrew Brettler, the big dog. Big dog Brettler. We love Big Dog Brettler here, don't we, folks? We love Big Dog Brettler. Prince Andrew's lawyer. We love Big Dog Brettler. Big AB. I don't sweat. Okay. So there was some meeting today, and we'll get another document soon. Yeah, I mean, this whole thing is a date for jury trial. That's where this sort of basically this is the main thing that we had an update to today. Is that they set a date for jury trial next year. So okay, it looked like maybe that temporary restraining order was granted, but no, it hasn't been signed by a judge yet. It's not actually granted. They've just put forward for it. Okay. Okay. That's interesting stuff. That's really interesting stuff.